Mr. Tavores Henderson first, please. All right, Mr. Henderson, you've got a few things that we need to address. First of all, you have a charge for aggravated assault of a family member pending out of the 263rd District Court. That judge has forfeited that bond and set your new bond at $0. So you will have to ask that judge, Judge Martin, to set a bond for you on that case when you get to that court. Would you like to have a court-appointed lawyer? Yes? And are you a U.S. citizen, sir? All right, so that matter is taken care of. You also have a warrant for your arrest on a misdemeanor case of assaulting a family member. When a warrant is issued, that just means probable cause has already been determined by another judge, so we don't have to go through that step of the process. You also have a warrant for your arrest for murder. Again, since a warrant was issued, that means probable cause has already been determined. So we don't have to worry about step one, but we do need to set a bond for you, sir. Would you like to have Ms. Jones help you on those two cases in setting your bond?
Yes, sir.
All right, Ms. Jones.
Judge, on the misdemeanor case, resting for a $3,000 personal bond, and on the murder charge, resting for a $75,000 bond. Mr. Henderson is 21 years old. He is a father of two and engaged to be married. He provides financial support for both his fiancee and for his two children. He is a native of Houston and lives with his aunt and his brother. He works part-time as a barber, but also relies on Social Security income. He had no pending charges at the time of this offense. He also has no prior misdemeanor or felony convictions. He has had one failure to appear in the past 2 years and no failures to appear in the past 2 years.
And the state's recommendations, please.
On the family assault, we're asking for a $5,000 bond, and we filed a MOAB. On the aggravated assault of a family member, we're asking for a $50,000 bond, and we filed a MOAB. And on the murder, we're asking for a deny bail. The defendant is currently, he was indicted for a felony of aggravated assault of the family member when he did commit this murder.
All right, on the aggravated assault case, the judge has already forfeited that bond and set that bond at $0. So that's
Okay.
that's already done and dusted. And I think there is a protective order already issued in that case, isn't there? Or,
We remade one just in case.
okay. All right. And does the state have a position on personal bond on the misdemeanor case?
We oppose a personal bond.
Mr. Henderson, in the murder case, I'm setting your bond at $150,000. That's taking into account that you have a felony bond pending where you forfeited bond, which means you didn't show up for court, which is now set at $0, and you have a new misdemeanor charge for assaulting a family member, and you apparently have a hold out of Galveston County for attempted theft, where the judge has set that bond at $20,000. So I'm taking all that into consideration, as well as the allegations contained in the warrant. I have read the warrant. So taking all that into account, your bond's $150,000. You will be seeing the judge in the 263rd District Court. You already have or have asked for a court-appointed lawyer on that case. And certainly, sir, if you get to that court, you'll have another opportunity to talk to Judge Martin about your bonds and have a separate chance to argue your ability to make a bond or not make a certain bond. So Judge Martin will have the final say, I'm sure, on any bond reduction that you ask for. I'm sorry, sir?
I'm trying to get the bond lower, you said?
Yes, Judge Martin obviously can lower the bond. And when you get to that court, they're gonna have a lot more information in front of them than I do right here. Now, on the misdemeanor case, let's see, you're asking for 2,000 and 5,000. On the misdemeanor case, I'm gonna set your bond at $5,000. Given everything that I've just talked with you about, I'm not going to approve you for a personal bond on that case. I do need to ask you, sir, I assume that you do not have the financial ability to even post the $5,000 bond, is that correct?
I can make the lane.
Taking into account what your bonds are likely to be set on the other cases, though. And taking that into account and also taking a look at your financial affidavit, I'm just going to make a finding by clear and convincing evidence that you do not have the financial ability, as we sit here right now talking about this, to post a $5,000 bond, given that the other cases are pending. I do need to tell you, sir, that in misdemeanor cases, a person cannot be kept in jail simply because they don't have enough money to post either a cash or surety bond. There are exceptions to that. If I find by clear and convincing evidence that I cannot impose a condition in conjunction with your personal bond that will either assure your appearance in court or assure the public safety in general, then I can deny a personal bond and require you to post a cash or surety bond. In this case, given the charges that you have had in the past and that you have right now, I am going to find by clear and convincing evidence that there is no condition I can impose in conjunction with a personal bond that will assure the public safety in general. And that's based on, like I said, your past allegations and the ones that we have here present in front of us. We will be seeing the judge in court number 6 on that case. And Mr. Henderson, you do have a right to appeal my decision to that judge in court number 6. If Judge Andrews reviews what I've done and thinks I made a mistake, the bond can either be reduced or converted to a personal bond for you. So you have this built-in right to appeal, and I urge you to take advantage of that. So when you get to court 6, ask the judge to conduct a bail review hearing. Would you like to have a court-appointed lawyer in the misdemeanor case? All right, sir. Now, I do have some protective orders that I need to go over with before we're done. Did you ever get the, you know, if the misdemeanor, no,